Ladies and gentlemen, the Florida Supreme Court. Please be seated.
Good morning, ladies and gentlemen. Welcome to the Florida Supreme Court. We have, first on our calendar today, three consolidated cases: Tampa Electric, Florida Power, Florida Power and Light versus Garcia for argument. And as I have been advised, Mr. Davis, you are going to go first and have asked for 5 minutes. Is that correct?
Yes.
You may proceed.
May it please the Court, I'm Alvin Davis. I represent Florida Power and Light Company. We are one of the appellants. We are appealing from a determination of need decision by the Public Service Commission. Procrustes was a mythological innkeeper. When beds didn't fit the travelers stopping at his inn, he didn't adjust the beds. He lopped off the limbs of the travelers so that they would fit the beds in his inn. And that is what the Public Service Commission has done here. A merchant plant, which we are dealing with here, is a free market concept that does not fit within Florida's regulated monopoly concept of providing retail electric service.
Instead of us realizing we have limited time, it's distressing, as a matter of fact, because we realize now asking questions is going to, let me get right to. Does the record reflect, or can you tell us generally what the practice is in other states with reference to this issue? In other words, can we look around the Southeast or other states in the country with reference to the involvement of regulatory bodies in this regard?
The record does not reflect that in any detail, except to the extent that where plants of this merchant concept have been permitted, it has been in the context of deregulation initiated by the legislature as opposed to de facto deregulation by the regulatory authority.
Is there case law out there that reflects that? That is, that there are cases where courts have reviewed decisions of regulatory bodies and have drawn this bright line distinction. That is, that there's been some very express authorization with reference to this practice, and if there has not been rather express authorization.
Well, the only case that comes to mind at this point is the case in which Duke itself made the same argument in the North Carolina courts and prevailed on the position that we're trying to assert, that you can't have...
In keeping out another utility?
In keeping out a merchant plant, because the merchant plant didn't fit within the regulated monopoly scheme. And that case is cited in detail in the brief.
If Duke were to contract with Florida Power and Light or any of the other regulated utilities that are here today, would they then qualify under the statute to be able to build a plant?
If, in fact, all of the capacity that Duke is purporting to put into the market were subject to firm contracts with the utility, then the overall application would fit within the scheme.
Are we here on a policy issue or a strict statutory construction question?
I believe we're on strict statutory construction. The policy issue in this case belongs in the legislature and not in the PSC, and respectfully not in this court.
So could you succinctly state what definitions we have to look to and where the specific dispute is, and I think it's with the question of what a regulated electric utility means, but if you could just quickly...
As succinctly as I can, I think there are two principal statutes here that are involved, the siting statute and the Florida Energy Efficiency and Conservation Act, that has to do with when a utility may build a plant. That is required they're required to establish a need for that plant to serve their customers. And that is the narrow statutory issue that's involved here. The PSC veers dramatically from that.
Isn't the question what an applicant is for the purpose of it?
Well, there are two questions. One is who is a proper applicant, and we don't believe that Duke is a proper applicant.
And by saying that you don't believe it, it's because you say that you don't believe that the statutory
definition... Because the statute does not cover Duke.
The applicant goes to, you refer to then utility? Or you referred, what is the next? You go from
Applicant under this statutory scheme is a utility that serves retail customers in the state of Florida. It does not do and has announced it has no intention of doing.
Could a Florida regulated utility build a merchant plant in Florida?
No.
Okay, so basically your plan, your argument is that a merchant plant falls outside of this statutory scheme for the certificate of need.
That's correct. A freestanding merchant plant that simply is a source of power and capacity does not fit within the scheme.
Well, if it falls, what I'm trying to get to is that there's an argument made by your opposition that if the PSC were to narrowly construe the Siting Act to exclude EWGs regulated as public utilities, new electric generating facilities constructed by EWGs in Florida could fall outside of the Siting Act and the PSC's general regulatory oversight. I mean, is there a method here by which they could, a merchant plant could be built, but not come within the Siting Act, and not come within PSC jurisdiction?
No. A merchant plant must be associated with a specific utility's needs in order to be built in Florida. That's the existing statutory structure. If there's a change in that, the legislature may make the change. But the point of it is, and it's been argued very well in the brief, and my time is up, I apologize, but if I may just finish my answer to this question. There is an overall scheme that is clearly articulated, and it fits together very well within the context of a regulated monopoly. And that is, utilities are required to serve retail customers. They have to show that the plants that they propose are needed to serve those retail customers. You cannot simply build plants willy-nilly all over the state of Florida, because the policy of the state of Florida, as articulated in the legislation, is that we don't want to have a bunch of plants all over the state of Florida because of conservation concerns, because of environmental concerns. Therefore, if you're going to build a plant, you have to show that you, as a regulated utility providing services to retail customers, need that plant to serve those customers. That's the existing scheme, and that's what the PSC was required to enforce.
So did I understand you correctly earlier to say that if Duke had agreements with people other than New Smyrna that would take up all the capacity of this new plant, that then the scheme would be okay?
Yes, because they would then be serving a utility that has the need that is being met. But Duke consciously determined not to do that so that it can sell to anyone it wants, which is a free market concept that does not fit within the scheme. Thank you.